Welcome to the Juvenile Delinquency Courthouse. This video has been created both for youth who are in custody and those who are out of custody, and their families and/or legal guardians. It will guide you through the procedures followed by the Sacramento County Juvenile Delinquency Court in carrying out its goals and responsibilities as mandated by law, to provide treatment and rehabilitation for minors, hold them accountable for their behavior, protect the public, and assist victims and the community to recover their losses. Young people under the age of 18 come to juvenile court when accused of breaking the law or violating probation. In adult court, such people would be called defendants, but in juvenile court, you will be referred to as the minor. If the charges against you are found true, you will be placed on probation, which will include some punishment and treatment. In this video, we will take a look at each stage of the juvenile delinquency process for minors who are held in juvenile hall and those who are not. For each court appearance, parents or guardians of minors not in detention arrive at the courthouse with them. Parents or guardians of minors in detention will meet up with them in the courtroom when their case is called. Inside the entrance of the courthouse, you will pass through a metal detector. In some cases, you may have to remove items such as your belt, shoes, jacket, or jewelry. While inside the courtroom, all cell phones and pagers must be turned off. Appropriate attire and conduct, as explained in the trifold pamphlet mailed to you, are required of minors, their parents and guardians, and any accompanying family members. Both your clothing and conduct display respect for the court and show the court that you take the case seriously. If attire and conduct are not in compliance with the court rules, you will not be allowed in the courtroom and your case will be rescheduled. You must first report to the reception window. There you will be given a pager and a probation report. You will be directed to your courtroom and instructed to wait in the seating area outside that courtroom. Unless you intend to hire an attorney, the court will appoint one to represent the minor. Once you are in the waiting area, the attorney will use the pager to contact you to discuss your case before your court appearance. The purpose of that meeting is to gather information, such as how the minor is doing at home and at school. It is important to understand that the attorney represents the interests of the minor, not the parent or guardian.
You got that?
Once inside the courtroom, you will see a number of courtroom participants. The judge sits at the front of the courtroom on a raised platform known as the bench. The tables facing the bench are the counsel tables. At one sits the deputy district attorney, who is responsible for bringing the charges to court and for proving that the charges are true. Seated at the other counsel table is the defense attorney, who is there to provide legal advice for the minor and to protect the minor's rights. The minor sits next to the defense attorney, and the parents sit next to the minor. If the minor or parents require an interpreter, the interpreter will sit near them. Seated near the judge's bench is the courtroom clerk, who keeps track of all the orders of the judge, and the court reporter, who records the words that are spoken in court. A sheriff's deputy sits at one side of the court as a bailiff, maintaining security in the courtroom. A probation officer acts as the presenter, who makes recommendations to the court about your case, provides last-minute case information, and researches probation issues at the court's request. When hearings conclude, probation officers will provide relevant information to any departments or agencies involved in your case. The juvenile delinquency court process consists of a series of hearings. The first hearing is either an arraignment hearing or a detention hearing. The next hearing scheduled will be a settlement conference. After that, there may be a jurisdictional hearing, which is the trial, and/or a dispositional hearing. When the minor is out of custody, the first hearing is an arraignment. At this hearing, the judge informs the out-of-custody minor of the criminal charges he or she faces. The defense attorney usually will meet with the minor before court in an interview room to discuss the charges. The charges may be different than the ones the minor was arrested for. The deputy district attorney bases the charges on the police reports and other information from the minor's history, including behavior at home, school, and in the community. When the case is ready, the parents and the minor will be paged by the presenter to enter the courtroom. In some cases, the minor may admit to the charges at this hearing and receive punishment and treatment as part of probation. However, in most cases, the minor will not admit at this stage, and the matter will be scheduled for future hearings. When the minor is in custody, the first hearing is a detention hearing. This is a brief hearing to determine if the in-custody minor will be detained, released without restrictions, or released with restrictions. Before the detention hearing, the minor's attorney usually visits the minor in the detention facility on the morning of the hearing to explain the procedure and gather information about the minor's home and school environments. When the minor's case is ready to be heard, the parents will be paged by the presenter to enter the courtroom. At this hearing, the probation officer, deputy district attorney, minor's attorney, and the parents provide information to assist the court in making a decision that is in the best interests of the minor and protection of society. If the minor is released at the detention hearing, he or she will usually be required to comply with restrictions that will include curfew, school attendance, and return to court. Probation officers monitor the minor's compliance with the conditions of release. Other restrictions might include home supervision, where the minor is contacted daily by deputy probation officers, or electronic monitoring, where the minor is monitored 24 hours a day, 7 days a week, using computer technology and a tracking device that the minor must wear. Whether the minor is in or out of custody, the second hearing is the settlement conference. Before this hearing, in the judge's chambers, the minor's defense attorney, the deputy district attorney, and the judge attempt to reach an agreement to resolve the case without the necessity of a trial. If, at the settlement conference, the minor admits responsibility for committing the offense, the judge will ask the minor a series of questions to make certain that the minor understands his or her rights and understands the consequences of admitting responsibility. If the minor admits responsibility, a dispositional hearing generally will be heard immediately or will be scheduled to be heard 2 weeks later. Here, the judge will review the minor's social study report that is prepared by the probation department in advance of the settlement conference. The judge will hear comments from both the minor's attorney and the deputy district attorney. The judge may then hear comments from the minor's parent or guardian, as well as from the minor. On some occasions, victims and victims' family members may make a statement.
Yes, Your Honor.
The judge will decide how the minor will be rehabilitated, how he or she will repair the harm caused to the victim and the community, and what sort of punishment is necessary.
You also must comply with our general terms of probation that you live inside.
If the minor does not admit responsibility, the case will be scheduled for a trial called a jurisdictional hearing. At this hearing, evidence and witness testimony are presented to the judge. During the jurisdictional hearing, the deputy district attorney must prove the charges. After the deputy district attorney questions his or her witnesses, the defense attorney will have the opportunity to question each of those witnesses on what is called cross-examination. After the deputy district attorney presents all of his or her witnesses and evidence, the minor's defense attorney has the opportunity to present witnesses and other evidence on behalf of the minor. After the minor's attorney questions his or her witnesses, the deputy district attorney will have the opportunity to cross-examine each of those witnesses. If, at the conclusion of the jurisdictional hearing, the judge determines that the charge or charges are not true, the the case is dismissed. If, on the other hand, the judge determines that the charge or charges are true, the case proceeds to a dispositional hearing, the time when the judge will impose punishment and treatment. Whether the minor admits responsibility or the judge determines after trial that the charges are true, dispositions may include community service, home supervision, electronic monitoring, counseling or treatment, restitution to the victim, court fines, and foster care. They may also include commitment to juvenile hall, the Warren Thornton Youth Center, the Sacramento County Boys Ranch, or the State Division of Juvenile Facilities. These requirements, along with others such as attending school, drug testing, and obeying all laws, are court-ordered conditions of probation. When you leave the courtroom, you will go downstairs to Window 1 in the reception area to go over these conditions with the probation office. You must comply with these orders to successfully complete your term of probation. If you do not comply with your conditions of probation, you will be brought back to court for violation of probation and a new dispositional hearing. In some instances, you will come back to court at the conclusion of your probation period. At that time, the court will review your case to see if you have successfully complied with all of the probation requirements. If you have, you will be released from probation. If you successfully complete probation, you can request to have your juvenile records sealed. This means you have a chance to learn from your mistakes, make amends to the victim and/or community for your actions, and not have this juvenile record count against you in the future. We hope the information provided in this video helps you understand how the juvenile court system works in carrying out its mandated duty, not only to provide treatment and rehabilitation for minors, as well as punish them and hold them accountable for their behavior, but also to ensure public safety and protect victims and the community by helping them recover their losses. For further information, please visit Sacramento County Superior Court's website at www.saccourt.ca.gov or the Sacramento County Probation Department at www.probation.saccounty.net.